You can look around and see how people are dressed when they come to court. This is felony court. This is where you can go to prison. You don't show up wearing shorts and go find some pair of sweatpants. Sweatpants aren't allowed. Shorts are for sure not allowed. All right. This is somewhere where you need to dress as nice as you possibly can in the future. So this is your initial appearance, Ms. Baldwin, and cause number 26 DCCR, Mr. Baldwin, I'm sorry, and 26 DCCR 0899. You're charged with the state jail felony offense of engaging in organized criminal activity. And that is from March 1st of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
My father told me he was gonna talk to Burbank.
Okay.
I don't know if he did though.
So here's what I'm going to do. I'm going to reset your case for about 30 days to give you some time to try to hire someone. If someone's helping you, that's great, but ultimately it's your responsibility to make sure you talk to at least 3 lawyers. All right. If you get someone hired before the next court date, you just bring the reset notice that you get today to that lawyer and they'll tell you what to do. But if you're not able to hire someone, then again, you need to talk to at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand? Same thing. When?
No.
Yeah.
Before I went to jail on my misdemeanor.
That doesn't tell me anything. When's the last time you smoked or used anything that contained THC in it?
More than 3 weeks ago.
Good. Obviously, that's not a good idea while you have a felony pending. Do you understand that now? I don't care. Again, just like I told him, I don't care if it's legal, illegal. If it has anything that's going to make you test positive for THC, you're not allowed to use it at this point because I have to make sure you're not doing anything illegal. And that's the only way I know. You're going to be required as a condition of your bond to have a drug patch put on within 24 hours. So between right now and tomorrow at noon, I want proof to your bondsman that you have that drug patch on. They can tell you where to get it. It's a patch that goes on your arm. It's up to you. You better keep it on there. Make sure it stays. You have to go every 2 weeks, get it changed. If yours should be barely positive this next time, it's going to have the amount in your system on it. So it's not just a positive or negative. So I'm going to know if your amounts are going down or not. If that amount's not going down, and if you're not clean within 2 patches, I'm going to assume you're still using, your bond will be raised and you're going to be back in jail. Do you understand? Any questions about that? So I want everything same that I already told you. You need to work on getting a lawyer. You need to work on having a job and bring me proof of all of that. Step in front of the clerk. If I test you this morning, you can have something in your system. Have seen the jury boxes, double check that first.
Or chair on the front.
Remember about August.
One, two, three, four.
The one, yeah. Let me look and see. Mr. Malone? Yeah. Mr. Malone, I found that you do qualify for a court-appointed lawyer. And so where do you work? What do you do?
81 sheet metal, and I'm the welder and fabricator. And then we go to plants and do just whatever they need. It's like metal.
Where would you be traveling, I guess,
mainly
outside of?
mainly the paper mill in Evadale.
Okay.
That would be the main spot, and then sometimes stuff comes up. This and it might be out of county. It's all depends. I actually don't go in any of the plants because of my background,
Right.
but I do go to the paper mills and other places, you know. That do allow.
You've got your GPS on?
Yes, ma'am.
Okay. So I will modify the conditions of your bond. Evadale's in, what county?
I wanna say, is it Orange?
Maybe. Do you know, is it Orange? So I'm gonna allow you to go to Evadale. Also, here's what you can do for your work, and probation's gonna take note of it. You're on probation, obviously. So you're still supposed to be doing everything you're supposed to on probation. So as a condition of your probation, I will allow you to leave with permission. So you've got to let your probation officer know if you're leaving. So you can't just go and then come back and say, oh, by the way, I went. You need to let them know, call. It's another step you have to take, but that's the only way I'm gonna allow you to do it.
Is there any possible way I could go to Tyler to see my mother?
You need to ask permission from probation first. So just ask them, they'll send something over to me. I take a look at it. I have a pile of stuff I look at every day from probation, and then I'll make that decision. Okay?
One other thing, I've asked Miss Bradley several times. And she just tells me, no, there's no way you're doing anything unless the judge says.
Well, at this point, she's correct.
Yes, ma'am.
So you have to ask and then she'll ask me. All right, so she'll send us something over in writing, so I have a paper trail of where you're going, and then we all are on the same page. So probation's here today. They're gonna let her know that I'm potentially gonna give you some permission to work outside of the county, possibly go see your mom, but you're gonna have to go through them to do that.
Yes, ma'am.
Okay? All right, step in front of the clerk.
Right. Evadale Jasper County Judge.
Jasper?
Yeah.
Okay, thank you. Do what? Okay.
Were you on the?
Mr. Malone, do you have court date in Orange yet on that case?
He's got.
It did? Okay.
That's what Miss Bradley. I'm not on that one. It's just honest. My last piece of that it.
That it has been?
Yes. I had for the bonds.
Jonte Harmon? All right. You can talk to.
Transfer to Burbank. Justin R. Gilmore, they didn't answer. Burbank did answer. They said they called me back. Henderson Stahl. They didn't answer. Brian. Withers. They answered I think the price was 7,000 and they do payments.
Okay,
And you could split it in half, but I don't have the type of money.
so I'm gonna have you fill out some paperwork this morning. Thank you for doing that and bringing it. I'm gonna have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk on the end, she'll give you that paperwork. Mr. Parker, you've got Stephen Gray. It's a sentencing.
He's outside, I believe.
Stephen Gray.
Stephen, right?
You stating right? Up here.
Good morning, you're Stephen Gray,
Yes, ma'am.
and this is cause number 26, DCCR 0294. Mr. Gray was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received the precedence report. Have you both had an opportunity to review that report?
Yes, Judge.
Any additions or corrections?
None of the word.
Not from state.
All right, I guess y'all have all taken a look at what the recommendation is because of the positive alcohol screen at.
Yes, sir.
So, Mr. Gray, it gives me a lot of concern that you showed up to probation and tested positive for alcohol when you are here on a driving while intoxicated third. So what that means is if I'm going to follow this agreement, then you're going to go in and get some serious treatment. And that's the only way I'm going to follow this agreement. Do you understand?
Yes.
All right, so this morning, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated third or more. I will sentence you in accordance with your agreement to a term of 10 years in prison, but probate that. Actually, I'm going to place you, the length of time, I know you guys talked about 5 years, but based on what I'm seeing here, I'm not going to follow that. I am going to order that you're on probation for 8 years. I'm going to order a $1,000 fine. You will be required to follow all of the rules and conditions of probation. One of those is you have to serve 10 days upfront time as a condition of probation. But more importantly, and in addition to that, I am going to order that you enter and successfully complete the substance abuse track of the ISF program. That's an inpatient program. You'll go in today, and then when you are out and released, you'll go through the JCDI program as your aftercare. And if you do everything you're supposed to and follow through with the treatment, then for all practical purposes, your case here in court will be over and you'll be able to serve the rest of your 10-year sentence while you're out on probation. But the other side of that is if you violate any condition of probation, you'll be back in court and you'll be facing that 10-year sentence that you agreed to. Do you understand?
Yes, I do.
I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. Also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, sir, you can go back with the bailiff. Thank you, Mr. Parker.
Judge.
Yes.
Almost looks up.
See, Mr. Rojas, you have Tashawn Bass.
Yes, it was.
Hey, how are you?
Good, how are you?
I'm good. It's Monday.
And yet you're still good.
Still good. Hey, I've been called Darlin this morning, which is better than some other things that we call.
Oh.
Darlin.
I never get called Darlin.
Oh,
Thank
sweet
you.
Miss Logan.
That's even better. Yes.
Good morning. Are you Tashawn Bass?
Yes.
And Mr. Bass is here in 2 cases, cause numbers 25 DCCR 0832 and 0833, charged with aggravated sexual assault of a child. And what is the announcement?
Judge, Ms. French ordered the CPS records in June, and I don't believe they've come in yet. I checked this morning, they're not here yet.
Okay, yeah, I see that I signed that. We should be getting closer. So let's just do maybe 45-day reset so that we can see, hopefully we'll get those back. She can get them, y'all, everybody take a look at that. We'll see if we can get an announcement the next court date. Make sure you stay in touch with Mr. Rojas so that once he gets all that information, you can go over it with him and we'll get an announcement. All right, you're free to go.
She's at Crimes Against Children
Yes.
Judge. I will send her an email so that she sees it.
To follow up with you. Thank you.
Thank you, Judge.
Thank you. This is the day. Ms. DeLage, you've got Carly Davis.
Yes.
Looks like that's set for a plea. Are y'all working on paperwork?
We have, it's a partially agreed plea. We need a plea open as to the conditions of the probation.
Okay, you can just get all the paperwork done on that.
Okay.
Thanks. Mr. Jeffries, you have David Boyd.
Judge, that's one of Mr. Coleman's, and I've been facilitating, Mr. Jeffries had some questions this morning. If we could just hold it and get an answer on that, I think they'll probably both be announced and ready for trial, but I just want to make sure.
Okay, let me hold it just a minute then. Thanks.
I don't wanna do that.
Yeah, that's right. He's in parking court this morning. But what is, do we have announced? Hold on a second, let me look at what. Well, it's much better and it's a child. Okay. Mr. Gertz has Larry Fletcher with Mr. Coleman. Mr. Gertz is announced ready. What is this? All right, I'll number that one. And then also with Miss French, Mr. Gertz has Jesse Salinas, and there's an announcement of ready as well.
Could I hold on that, Judge? Pam sent a lengthy email to all of us over the weekend. I think she has received, I don't know, via a subpoena or an unexpected drop off of some voluminous discovery packet. I know she's talked to Mr. Gertz about that, send it to him. So
Okay,
if his announcement has come subsequent to that,
maybe so.
I'm sure that hers would also be ready. I know she was up until that was dropped on her desk on
Okay,
Friday.
let me hold it and see if that has changed anything.
But I'll
maybe
try
you
to
could do
catch
it.
her on a lunch break or something, but she
Yeah.
did send us.
Okay, yeah.
She was expecting him to ask for the recess.
She told her that. Right. And she just thought it was probably gonna be a problem. Okay, all right, I'll make note of that. Ms. Holmes, you've got Trinity Bell. Morning.
This one, we're still waiting on a refile to get completed.
Refile.
Um. We needed a new PC affidavit before they would refile it. And they sent an email to the officer and they hadn't come in to sign the information and complaint misdemeanor yet.
Okay.
We just reset it a couple of weeks. We'll should be able to get it taken care of.
Yeah, if you'll make sure that that officer knows that I'm waiting on it for him for her to get in there. Trinity Bell. All right, I'll reset it. We'll do 3 weeks.
Okay.
And hopefully that'll give you guys plenty of time. Miss Bell, I'm gonna reset your case 3 weeks. It sounds like it's gonna get refiled as a misdemeanor, but it hadn't been done yet. Stay in touch with Miss Holmes. So if that happens between now and then, and you need to go to court, go take care of that. And it sounds like it'll take care of this one. Otherwise, if that hasn't happened yet, let's see back in 3 weeks where we are.
Okay.
Okay, yes, all right, you're pretty good. And then Ms. Holmes, you've got Michael Garrett.
Yes. Your Honor, on this one, the complainant is scheduled to meet with Mr. Snett today. And we think that would dispose of the case, so we probably just need one week.
Okay, well, let's do 2 because we don't have a docket next week, so we'll do a 2-week
He's
reset.
called in, but he was out of town, but he's
Okay.
in town today. So
Okay, and if something gets taken care of and I mean, you can if there's something that makes the case go away, that can happen before that court
Yeah.
date. So I'm gonna reset your case for 2 weeks. If Ms. Holmes tells you your case is taken care of, then you don't need to come back, fine. Otherwise, make sure you're here in 2 weeks, okay?
Yes, ma'am.
All right, see you then. Then you've got, I'm signing a dismissal and calling Savet, he's free to go.
Thank you.
Yes, ma'am, thank you, have a good day.
No.
Like they don't know that part of their duties.
And raise y'all, he needs to talk to y'all first.
And maybe I need to talk to them because we haven't had many of them and explain. Because apparently they're doing it. I mean, why do you say that? That they were supposed to be doing that the whole time, yeah. Mr. West, you have Jeremiah Douglas. It's a sentencing, 2 cases. Good morning, you Jeremiah Douglas. And Mr. Douglas, you were previously in court in cause numbers 25 DCCR 1115 and 12222. Entered pleas of guilty in each of those cases. I've received the pre-sentence report. Have you both had an opportunity to review that
Yes, sir.
report?
Yeah, I sure on the state has,
Any additions or corrections?
not from the defense, not from the state.
All right, Mr. Douglas, in each of those cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty. In cause number 251115, defer all proceedings in accordance with your agreement for a term of 5 years. You'll be placed on probation, $500 fine, and be required to follow all of the rules and conditions of probation. And then in cause number 251222, also follow that agreement, defer all proceedings, place you on probation for 5 years. You'll be ordered to pay a $500 fine in that case, and also in both cases, obviously follow all of the rules and conditions of probation. If you do that in these cases, this is an excellent opportunity because you don't have felony convictions on your record. And at the end of the probation periods, if you successfully complete the probations, the cases will actually be dismissed. You'll never have a felony conviction. The other side to that in each case is that if you violate any condition of probation, you can be brought back into court, found guilty in each case, and sent to prison in each case for between 2 years and up to 10 years. Do you understand?
Judge, I would ask, just based on some of the contents of the PSI, that a substance abuse assessment be done, whether to determine if he needs JCDI or something.
Thank you. I will do that. So that you're going to submit to a substance abuse assessment. If that assessment says that you need any kind of treatment, then that will be ordered and you'll be automatically have to do it. You're not going to have to come back to court. I'm saying now you'll have to do it. Also, a condition of your probation is that you're not to have any firearm at all. That's a standard condition of probation. Let's see if there's anything else I want to. All right, so I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you, Mr. Nichols, Mr. West. Mr. Jeffries, have y'all heard from Mr. Coleman yet? Okay.
That's fine.
Okay,
It's a key.
I'll hold it for just a few more minutes. See, Mr. Lewis, you working on something?
Yes.
Okay, I'll hold yours.
Tommy's keeping this case. Tommy's ready for trial.
And we are ready for trial as well. I do want to add a caveat in there. I believe we're scheduled for the 17th. I have a trial in Madison County on the 10th. That's a sex case that could potentially pour into a second week. But
Okay.
I'll keep you updated as that develops.
Okay. And sir, you're David Alexander Boyd?
Yes.
And this is 25 DCCR 0720, and Mr. Boyd is charged with deadly conduct, discharging a firearm. I'm going to number the case tomorrow after docket. I do want to make sure you understand, Mr. Boyd, that after today, I don't take plea agreements unless there's some new information that comes up. So today's the day for that. Otherwise, I'll number the case, and Mr. Jeffries will know tomorrow after lunch what that trial order is. And I would anticipate you being back on Monday, the 17th for trial. All right.
Thank
And
you.
I'll make a notation of that as well, that you let me know that about that trial.
Yes.
Okay. All right.
Thank you
Very
very
good.
much.
Thank you, Mr. Footsmith. Very up you. Mr. Pelican. Come on. All right. When's the last time you smoked marijuana? So listen before you answer that, because you already told me you were going to test negative. So you already haven't told me the truth this morning. Before you answer that, you need to understand that what's going to happen after today is you're going to be wearing a drug patch, and it's going to test the amount of THC in your system. So I'm going to know within 2 weeks how much. So when was the last time you smoked?
Like 2 weeks ago.
What made you think that was a good idea while you were waiting on coming to felony court?
It was.
Same kind of decision, like quitting a job before you have another one?
Yes.
Maybe some of those bad decisions are because you're smoking marijuana. So here's what you're gonna do. You're gonna have a drug patch put on within 24 hours. So tomorrow by noon, you will have a drug patch put on. Those drug patches, you have to get changed every 2 weeks. You have to make sure it stays on. There's no, oh, it fell off in the shower, whatever it takes. I want it on, I want it testable, and you have to have it tested every 2 weeks. I understand, based on what you told me, that you should probably test positive one more time. After that, the amount should be almost nothing. If it's not, then I'm gonna have to assume that you're still using, and then your bond's gonna be raised and you're gonna go to jail, which is what could have happened today. Okay? It's a violation of the law. It's a violation of your bond condition to use anything. And at this point, I'm going to order you use nothing that could test positive with THC. I don't care if it's legal or illegal or whatever. So you can't use anything. I need to know that you're clean from everything. Make sense?
Yes.
And then you need to get a job, which will be a whole lot easier if you're clean, and bring me proof of what you've done to get a job between now and the next court date.
Yes, ma'am.
Okay? Step in front of the clerk. She'll give you a reset notice. Ms. Baldwin, Mr. Baldwin? And this is 26 DCCR 0420. Ms. Ballard's charged with burglary of a building. And what is the announcement?
Judge, we got a new offer from the state that involves some upfront restitution. Talk with her and her family. They can have the money within 2 to 3 weeks.
Okay, so just a normal reset.
She had filled out the papers. I think there was just a miscommunication. I was willing, based on the facts, to offer a misdemeanor. She paid the restitution. She can do that.
Let's just do a normal, I'll reset your case 30 days to give y'all some time to come up with that restitution. If so, it sounds like the case will get taken care of. If not, then you'll need to talk about some other options, okay? All right, we'll see you in about a month. Akaya Nash. Or Ikea Nash. Akia Nash.
You live in the Z, I saw this morning.
Okay. Back here for a second. Good morning. Is it Akaya?
Yes, ma'am.
Akaya Nash, and this is 26 DCCR 0206. Ms. Nash is charged with aggravated assault with a deadly weapon, and what is the intent?
Judge, I've met with Ms. Nash and I've talked to Mr. Smith about this case. And it's one I think we're close to getting a resolution, but I believe he wants to speak with the complaining witness first
Okay.
before we do that.
Right, so what I'll do is just a normal reset, give Mr. Smith some time to do that, and let's get an announcement at the next court date.
Yes, ma'am.
Stay in touch with Mr. Lewis. He'll let you know when you need to be back, okay? You're free to go. Lance Charbino.
Sure.
Good morning, sir. Are you Lance Charbino?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Charbino, in clause number 25, DCCR 0096, you're charged with the state jail felony offense of credit or debit card abuse from September 10th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be no fine, but there would be restitution ordered in the amount of $5,000. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State charge number 1.
No case.
It's admitted. Is there any evidence that Mr. Charbino is not competent?
No case.
And Ms. Molfino, since we have that amount and it's a state jail, any issue with waiving?
No, Judge, there's no criminal history but for his being involved in an accident, which did not allow him to pay the restitution, we would have dismissed it.
Okay, so what I'm going to do is waive the pre-sentence report. Find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 3 years, place you on probation. You're ordered to pay the $5,000 restitution and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is an excellent opportunity because you don't have a felony conviction on your record.
Yes, ma'am.
And at the end of the probation period, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, and go to the state jail prison for up to 2 years. You understand?
Yes, ma'am.
Also, $5,000 is a lot of money to get paid off, obviously. I want you to start making payments on that immediately. So as soon as you can and make payments. Also, if you get it paid off early and do everything else that you're supposed to and take care of everything on your probation, there's no reason that you can't get off your probation early. But you have to have done everything right, get that paid off. Probation sends it over to me. I sign early terminations all of the time. All right.
Question.
Yeah.
How do we go about paying?
You'll go through probation. They'll let you know how to do that. I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's at that desk right there. She's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
All right. Good luck to you, sir. Thank you.
Thanks, you.
Oh, okay. I can do it without. Give me just a second. Let's see. Well. Let's see if you want to bring Spindletop and Mr. Brown out, please.
You need a whole bunch here.
Yes, please.
Let me know, we've had a change of plans, we're not doing a legal.
All right, give me just a second. Let me do this so I can take a look at it. Morning. How are y'all? Y'all come on up there. Whoever's gonna be the spokesperson can. How are you? Good, how are you? Good. Good morning. Come on up, sir. You're Michael Brown?
Yes, ma'am.
And Mr. Brown, I had you brought over today so that Spindletop can go over some things with you to see if you qualify to be released from jail on a personal bond. With the requirement that you would be willing to participate in any services that they would offer. So that's if you want to participate in those services, then I would consider letting you out to do that. Do you understand?
Yes, ma'am.
You would, and you've had an opportunity to talk to them this morning?
Yes, ma'am. I'll talk to them.
Okay, and so, ma'am, would you please raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And what is your name for the record?
Ms. Rodriguez.
And Ms. Rodriguez, you've had an opportunity to speak with Mr. Brown this morning,
Yes, ma'am.
and you're here on behalf of Spindletop, correct?
Ma'am.
And what would be the plan for Mr. Brown if I release him?
To schedule an intake appointment with us, and engage in services, so he can go back to receiving medication. Staying services as well.
What would be the time frame on him being able to schedule that first appointment?
2 weeks.
2 weeks? Okay. So, Mr. Brown, the most important thing is if I release you, you've got to schedule that appointment and show up for it and start those services. If you don't, then they're going to let me know. And so within 2 weeks, I want that first appointment and assessment done.
Bus stop right in front of me.
Good. And so the thing is, if you don't do that, then I'm gonna have to raise your bond and you're gonna have to go back to jail to wait on your case. And I don't want that. I want you to get the help you need. Sounds like you're willing to comply. So what I'm going to do is reduce your bond in your case to $1,000. I'm going to make that a personal bond. That means you don't have to pay any money. If you don't show up for court, it means you might have to pay that money.
Oh, no, but they don't let me know.
Everybody, they're gonna yes, they'll let you know when you have court, if you need transportation, they can help you with just about anything you need. So the main thing is that you ask for that help, okay? Let them know if you're having issues, make that appointment and start taking care of everything you're supposed to. You will keep your court-appointed lawyer. Who's that? It's Mr. Parker, that's right. Okay, it may be a little bit because your case isn't indicted, but he'll still be your attorney. And so we'll let him know that you're getting out and then he'll stay in touch with everybody as well, okay? All right, so make sure you take care of everything you're supposed to. Okay, good. Thank you, sir. Thank you all for being here. Mr. Smith on Fedro Gatlin Lassant. Good morning. Good morning, sir. Are you Fedro Gatlin Lassant? And this is 26 DCCR 0331. Mr. Lassant's charged with aggravated assault causing serious bodily injury. And what is the announcement?
Yeah, it's my understanding that the judge actually needs just a little bit more time to talk to the defending witness.
Ms. Malfino?
Well, I was ready to extend an offer this morning, but I just haven't yet had an opportunity to speak with Mr. Smith. He's been busy. So if we could hold it just a few minutes.
That may be the case. I have reached out multiple times.
That'd be
to
fine.
him.
I'll
We
hold
keep
it.
missing each other on the phone. It's not that I can't find him. We just miss one another,
All right.
but
Let me hold it for a few minutes. Just have a seat here in the courtroom. Rebecca Glaze. You need me to hold that one as well? Yes, I'll hold that so y'all can visit. James McEwen. Go about the attachment. Okay. Good morning, sir. Are you James McEwen?
I am.
And Mr. Smith, will your client waive the formal reading of the indictment?
He does.
Mr. McEwen, in cause number 25, DCCR 1186, you're charged with the state jail felony offense of theft of property from December 5th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
I do.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith?
I do.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be no fine, is that correct?
Yes, Your Honor. In
And-
the interest of getting that restitution paid.
Thank you. And the restitution ordered in the amount of $3,700. And you would be required to follow all of the other rules and conditions of probation. Is that your understanding?
That's my understanding.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. McEwen is not competent?
No doubt.
Mr. Nichols, what's the state's position on waiving pre-sentence reports?
We would ask the court to waive it. He has essentially 0 criminal history, Your
Okay.
Honor, and we have the restitution amount.
Perfect. So, Mr. McEwen, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay restitution in the amount of $3,700 and to follow all of the other rules and conditions of probation. If you do that, then this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case is actually dismissed. You'll never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 2 years. Do you understand?
Yes, ma'am.
That restitution obviously is a lot. I want it started to be paid immediately. I want something every month going towards that. If you get it paid early, there's no reason that you would even have to do the whole probation period. If you take care of everything you're supposed to, your community service and everything else, then you could get off of probation early. But it's very important to me that that restitution get paid. All right. I'm going to hand you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's at that desk right over there. She's going to call you up when she's ready to go over your paperwork.
All right.
All right. Good luck to you, sir. Thank you, Mr. Smith. Desiree Pugh. Good morning. Are you Desiree Pugh?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Pugh, in cause number 26, DCCR 0658, you're charged with the 3rd-degree felony offense of attempting to commit burglary of a habitation from February 17th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, states marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number one. It's admitted. Is there any evidence that Ms. Pugh is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done from probation. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Okay.
Okay, we'll see y'all back at sentencing.
Thank you.
Thank you, Your Honor.
The Jonathan Sosa. Good morning. Are you Jonathan Sosa? And will your client waive the formal reading of the indictment?
He does.
Mr. Sosa, in cause number 26 DCCR 0412, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And that's from February 1st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Guilty.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
Mhm.
Before you signed these, did you go over them with Mr. Smith?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You are agreeing to forfeit the weapon and to follow all of the other rules and conditions of probation. Is that your understanding? Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Any evidence that Mr. Sosa is not competent?
No, yeah.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right over there.
Yes, ma'am.
Okay, we'll see you
Thank
back
you.
at sentencing. We see Mr. Wilkerson. Mr. Burbank, you've got Kingston Walker. Good morning.
Good morning.
Good morning, sir. You're Kingston Walker.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
To get there. Mr. Walker, in cause number 25, DCCR 0862, you're charged with the third-degree felony offense of possession of a prohibited weapon from March 27th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $1,000 fine.
I'm sure I'm sorry to interrupt, I'm sure the court understands my language when I put in there, subject to all terms and conditions. Obviously, it's up to the court what things are ordered, but I would like to reserve the right and have the defendant know that, to ask for specific things as well.
Sure. So all the any condition of probation really is up to the court. And what I'll do today is reset your case for sentencing. Probation will do a pre-sentence report, and then depending on the information that I get, that'll help me determine what conditions to apply to your probation. Does that make sense?
Yes, ma'am.
And it looks like also the agreement.
And that's what makes real courtroom proceedings so fascinating. Every decision you saw today wasn't just about punishment, it was about accountability, responsibility, and the choices people make long before they ever stand before a judge. Sometimes the court offers a second chance. Other times, it draws a firm line that can't be crossed. One thing is certain, every hearing tells a different story, and every ruling carries real consequences that can change someone's life forever. What do you think about the judge's decisions in today's cases? Were the rulings fair, or would you have handled things differently? Share your thoughts in the comments, we'd love to hear your perspective. If you enjoyed this courtroom breakdown and want more real legal analysis, dramatic courtroom moments, and in-depth case explanations, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss the next courtroom story. Thanks for watching, and we'll see you in the next one.